Hi, my name is Chris Prescott. I'm the Senior Immigration Attorney at Patel Law Group. We are a full-service law firm based out of Irving, Texas. We also have offices in Houston and Oklahoma. My primary area of practice is business immigration law, and today I'm going to be talking about H-1Bs. The title of the video is an Introduction to H-1Bs. My intention is to give a broad overview of the H-1B program, and the video is specifically aimed at employers and employees that are not familiar with H-1Bs and are perhaps filing their first petition. As we record further videos, I will delve deeper into some of the complex issues which employers and employees face. However, for now, let's keep it simple and let's get started with the first question. A H-1B is a non-immigrant visa which allows a foreign national to come to the US on a temporary basis. It's one of the most commonly used visas by employers looking to hire foreign talent. In order to qualify for a H-1B, an applicant must be working in a specialized knowledge position and in a position which typically requires a US bachelor's degree or equivalent in a specific specialty. What that essentially means is that the position that they're working in must require a degree in a specific field. So an obvious example of a position which qualifies as a specialty occupation would be an attorney. To become an attorney, you need to have a law degree. Same thing with a doctor. To become a doctor, you have to have a medical degree. So those two are examples of positions where a degree is always a requirement, but to qualify for H-1B, you only have to show that it's a normal or a typical requirement, or that it's common within the industry. So to determine whether a position qualifies as a specialty occupation, we can look at the guidance provided by the Department of Labor in the form of the Occupational Outlook Handbook. And the reason I refer you to that is because this is what the agency that adjudicates these applications typically relies on. And that agency is USCIS. So if we look at, for example, the position of a software developer, the typical requirement for a software developer is a bachelor's degree in computer science, software engineering, or related field. What that means is that the majority of people working as a software developer have at least a bachelor's degree, and it's a bachelor's degree in an IT-related field. What it doesn't mean is that everybody working as a software developer has a bachelor's degree. So there may be candidates that have an associate's degree, there may be candidates that have work experience, but the majority of people working in that profession have at least a bachelor's degree. Now, some professions or certain occupations where more of perhaps a general degree is required, like a business administration degree, is going to have a much more difficult time of qualifying as a H-1B specialty occupation. So if you're going to be working in a position and you would like to find out whether it qualifies, I would suggest working with an experienced immigration attorney, and that way we can look, or whichever attorney you work with can look at what the typical requirements are for that position. To file for your first H-1B, you have to go through what's called the H-1B lottery process. So each fiscal year, Congress limits the number of H-1B visas available to 65,000 for those with a bachelor's degree and 20,000 for those with a master's degree. The H-1B program is a highly competitive visa program. Each year, USCIS receives in excess of 2,000 applications, and indeed this year they receive closer to 300,000 applications. The reason for that is that USCIS implemented a new electronic registration process, which required employers to submit a brief form online rather than an entire petition. So the registration process typically runs from March 1st until March 20th. Once all the applications have been submitted, USCIS will then run the electronic lottery and will notify successful applicants by the end of March. Those that have been successful in being selected will then have 90 days, essentially until the end of June, to submit an entire petition. Once that petition is submitted to USCIS, it will then go into the adjudication process, which typically means that USCIS will either approve the application or they may issue what's called a request for further evidence, also commonly known as an RFE. One thing to note is that an applicant only has to go through the H-1B lottery one time. So once you've been selected and approved for a H-1B petition, you can then file further extensions, amendments, or switch to another employer. And that's something we're going to talk about here shortly. In the normal scheme of things, USCIS should issue an approval for 3 years. However, in recent years, they've been issuing shorter approvals. This has become a huge problem for IT staffing firms. The reason for this is that IT staffing firms place their employees at third-party locations, and USCIS has been insisting that those employers show that they have work available for a full 3 years. Well, the reality is, in the IT industry, work orders are rarely issued for 3-year increments. They're typically issued for 6 months or 12 months at a time, and because of this, USCIS has been issuing 6 or 12-month approvals. Yes, spouses and children are eligible for H4 status. This is a dependent status which allows spouses and children to come to the US and spend the same amount of time in the US as the principal H-1B holder. It allows them to stay in the US, it allows them to study, but it does not allow the spouse to work. In the last question, we talked about the principal H-1B holder getting through the first 2 stages of the green card process, namely the labour certification, aka the PERM, and the I-140. So, if a H-1B holder obtains an I-140 approval, that allows the spouse to then apply for a work authorization. So the cost of filing a H-1B may vary. It depends on whether the employer hires an attorney to prepare the petition or whether they have experience preparing the petition themselves. Obviously the costs are going to vary from attorney to attorney, but let's look at the filing fees because they're going to be the same whether the employer files the application or whether they hire an attorney. So there's a number of fees that have to be paid to the government for each new H-1B application. First of all, there is a $460 filing fee. There's a $500 fraud fee, and then there is a training fee, which is either $750 or $1,500. That training fee is going to be dependent on the number of employees. So if an employer has 1 to 25 employees, the training fee will be $750. If they have 26 or more, it's going to be $1,500. In terms of additional fees, there is a premium processing fee, which allows applicants to expedite their case. That is going to be $1,440. The one thing to note about fees is that they are considered to be a business expense, which means they have to be paid for by the employer. The only fee that can be paid for by the employee is the premium processing fee, and that's only if the request to file in premium processing is done by the employee. If it's the employer that insists that the case be filed in premium processing, then technically it's the employer that should be paying that fee. In terms of the H4 fees, they are separate from the H1B, so they can be paid by the employee or the spouse. For the H4, there's a filing fee of $370, and then there's a biometrics fee of $85 per applicant. So let's take a family of 4. You've got the H-1B holder, you've got a spouse and 2 children. So for the H4, you would pay $370 for the application fee, and then you would pay 3 lots of $85 because you've got a spouse and you've got 2 children. The chances of obtaining H-1B approval will vary from case to case and will be dependent on a number of different factors to include the type of employer who is filing the petition, the type of position which is being filed for, and then the availability and quality of documentation to support that petition. Certain employers have been hit hardest, and those include IT staffing firms. IT staffing firms regularly receive challenges from USCIS questioning whether there's a valid employer-employee relationship, whether the position qualifies as a specialty occupation, and whether there is sufficient specialty occupation work available. However, by working with an experienced immigration attorney, you can identify these issues at the outset and ensure that the petition is properly prepared and that adequate documentation is included to overcome some of these issues. The employer is required to pay the prevailing wage. This is determined by filing a labour condition application, also known as the LCA, with the Department of Labour. The wage is determined based on location in terms of the state and the county where the individual will work. The wage will vary from state to state, so for example, an individual working as a software engineer in New York City will usually earn significantly more than the same software engineer working in, say, Columbus, Ohio. Each occupation has 4 different wage levels. Level 1 is an entry-level wage, Level 2 is for experienced workers, and Level 3 and Level 4 are for more senior positions that require an element of supervision. To determine the correct wage, we have to look at the minimum requirements for the position in question. So for example, if the position requires a bachelor's degree and up to 2 years of experience, that would be a Level 1 wage. If the same position required a master's degree and up to 2 years of experience, that would bump it up to a Level 2 wage. If that same position required more experience and/or an element of supervision, then that would bump it up to a Level 3 or a Level 4 wage. One thing to note, in recent years, USCIS has questioned whether Level 1 wages qualify as specialty occupation. Essentially, they argue because it's an entry-level position, it can't possibly be both entry-level and specialised. However, as I said, every occupation, whether it's an attorney, a doctor, a software developer, a software engineer, they all start with a Level 1 wage. So just because it's an entry-level position really has nothing to do with whether it's a specialty occupation, as long as the position requires at a minimum at least a bachelor's degree. So just to kind of conclude, the employer has to pay the prevailing wage. So if it's determined at $70,000, they can't pay any less. So for example, if they were to pay $65,000 against a prevailing wage of $70,000, they would be violating the regulations, plus it would give the employee the right to file a wage complaint with the Department of Labour. The H-1B doesn't necessarily lead to a green card, however it does make for an easy transition because the H-1B is one of the very few visas that allows for dual intent. Dual intent is the concept that you can have a short-term intention to depart the US and a long-term desire to become a legal permanent resident. What that essentially means is that you can file or at least start the green card process without it impacting your H-1B, and without it affecting your ability to travel. Most employment-based petitions are filed in either EB2 or EB3. That's a discussion for a later video, but safe to say that both of those categories involve a labour certification, also known as the PERM, and an I-140 approval. Once you have an I-140 approval, you then have to wait for a visa to become available. Just like the H-1B, Congress has limited the number of green cards available per year, and this is capped per country. So, for example, somebody from the UK, like myself, may be able to obtain a green card within a matter of a few years. However, somebody from a country which is oversubscribed, like China or India, may have a much longer wait, possibly 15 or 20 years. Yes, once you've been selected and approved for a H-1B, it is possible to switch employers. However, that new employer is going to have to file a brand new petition and pay all of those government filing fees all over again. The law states that as soon as that H-1B transfer petition is filed with the USCIS, you can then start work with the new employer. However, that does not come without risk. Imagine you're working for employer A and wish to transfer to employer B. Employer B files the transfer. If that transfer petition is denied, you would immediately have to start working for employer B. It then begs the question, can you go back to work for employer A? The answer is yes, but provided that employer A has not withdrawn the original petition. So, the best case scenario is to try and obtain an approval with employer B before transferring from employer A. However, in reality, employer B will probably want you to start working for them as soon as they file the petition. That's because they've gone to the effort of filing the petition and they've paid the fees. So to answer the question, you can switch employers, but you do need to be careful. Again, consult with an experienced immigration attorney. Thank you for watching today. For more information regarding H-1Bs, you can visit our website at patellegal.com. If you click on practice areas and then immigration, you will see that we have a dedicated area to H-1Bs. If you also go to the news and insight section, you will find a number of H-1B related articles. Thanks for watching and have a good day.